A. A Filipino citizen and his wife B. A Japanese national bought a 5-hectare agricultural land from X, a Filipino citizen. The couple later executed a deed of donation over the same land in favor of their only child, C. A year later, however, C died in a vehicular accident without leaving a last will and testament. Now, X brought suit to recover the land on the ground that B, being an alien, was not qualified to buy the land when B and A jointly bought the land from him, and that upon the death of C, the land was inherited by his parents, but B cannot legally acquire and or inherit it. How should the case be decided? If X filed the suit against C when the latter was still alive, would your answer be the same? Why? Answer: X cannot recover the land, whether from C or A and B. Under Article 4, Section 1, Number 2 of the Constitution, C is a Filipino citizen since his father is a Filipino. When A and B donated the land to C, it became property of a Filipino citizen, as held in Halili v. Court of Appeals. The sale of land to an alien can no longer be annulled if it has been conveyed to a Filipino citizen, since C left no will and his parents are his heirs. In accordance with Article 12, Section 7 of the Constitution, B can acquire the land by hereditary succession. Q. EAP is a government corporation created for the purpose of reclaiming lands, including foreshore and submerged areas, as well as to develop, improve, acquire, lease, and sell any land, all kinds of land. A law was passed transferring title to EAP of lands already acclaimed in the foreshore and offshore areas of Bay, particularly the so-called Liberty Islands, as alienable and disposable lands of the public domain. Titles were duly issued in EAP's name. Subsequently, EAP entered into a joint venture agreement, JVA, with ARI, a private foreign corporation, to develop Liberty Islands. Additionally, the JVA provided for the reclamation of 250 hectares of submerged land in the area surrounding Liberty Islands. EAP agreed to sell and transfer to ARI a portion of Liberty Islands and a portion of the area to be reclaimed as a consideration for ARI's role and participation in the joint venture. Upon approval by the Office of the President, is there any constitutional obstacle to the sale and transfer by EAP to ARI of both portions as provided for in the JVA? Answer: ARI cannot acquire a portion of Liberty Islands because although EAP has title to Liberty Islands and thus such lands are alienable and disposable land, they cannot be sold, only leased to private corporations. The portion of the area to be reclaimed cannot be sold and transferred to ARI because the seabed is inalienable land of the public domain. Article 12 of the 1987 Constitution, Chavez versus Public Estates Authority. Q. True or false? Explain your answer in not more than 2 sentences. Aliens are absolutely prohibited from owning private lands in the Philippines. Answer is false. Under Section 7, Article 12 of the Constitution, aliens may acquire private land by hereditary succession. Under Section 8, Article 12 of the Constitution, natural-born citizens of the Philippines who lost their Filipino citizenship may be transferees of private land. Q. In order to implement a big government flood control project, the Department of Public Works and Highways, DPWH, and a local government unit, LGU, removed squatters from the bank of a river and certain esteros for relocation to another place. Their shanties were demolished. The Commission on Human Rights, CHR, conducted an investigation and issued an order for the DPWH and the LGU to cease and desist from effecting the removal of the squatters on the ground that the human rights of the squatters were being violated. The DPWH and the LGU objected to the order of the CHR, resolved with position. Which position is correct? Answer: the position of the Department of Public Works and Highways and of the local government units is correct, as held in Export Processing Zone Authority versus Commission on Human Rights. No provision in the Constitution or any law confers on the Commission on Human Rights jurisdiction to issue temporary restraining orders or writs of preliminary injunction The Commission on Human Rights have no judicial power. Its power are merely investigatory. Q. Squatters and vendors have put up structures in an area intended for a people's park, which are impeding the flow of traffic in the adjoining highway. Mayor Cruz gave notice for the structures to be removed and the area vacated within a month, or else face demolition and ejectment. The occupants filed a case with the Commission on Human Rights to stop the mayor's move. The CHR then issued an order to desist against Mayor Cruz, with warning that he would be held in contempt should he fail to comply with the desistance order. When the allotted time lapsed, Mayor Cruz caused the demolition and removal of the structures. Accordingly, the CHR cited him for contempt. A. What is your concept of human rights? Does this case involve violations of human rights within the scope of the CHR's jurisdiction? Can the CHR issue an order to desist or restraining order? Is the CHR empowered to declare Mayor Cruz in contempt? Does it have contempt power at all? Answer of letter A. Under the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights, the scope of human rights includes those that relate to an individual's social, economic, cultural, political, and civil relations, along with what is generally considered to be his inherent and inalienable rights, encompassing almost all aspects of life. In the case of Bar, the land adjoins a busy national highway, and the construction of the squatters' shanties impedes the flow of traffic. The consequent danger to life and limb cannot be ignored. It is paradoxical that a right which is claimed to have been violated is one that cannot, in the first place, even be invoked, if it is in fact extant. Based on the circumstances obtaining in this instance, the CHR order for demolition do not fall within the compartment of human rights violation involving civil and political rights intended by the Constitution. Simon versus Commission on Human Rights. Letter B. The CHR may not issue an order to desist or restraining order. The constitutional provision directing the CHR to provide for preventive measures to those whose human rights have been violated or need protection may not be construed to confer jurisdiction on the Commission to issue a restraining order or writ of injunction. If that were the intention, the Constitution would have expressly said so. Jurisdiction is conferred only by the Constitution or by law. It is never derived by implication. Export Processing Zone, or PESA versus Commission on Human Rights. Letter C. The CHR does not possess adjudicative functions, and therefore, on its own, it is not empowered to declare Mayor Cruz in contempt for issuing the order to desist. However, under the 1987 Constitution, the CHR is constitutionally authorized in the exercise of its investigative functions to adopt its operational guidelines and rules of procedure and cite for contempt for violation thereof in accordance with the rules of court. Accordingly, the CHR, in the course of an investigation, may only cite or hold any person in contempt and impose the appropriate penalties in accordance with the procedure and sanction provided for in the rules of court. Carino versus Commission on Human Rights. Q. What is academic freedom? Discuss the extent of academic freedom enjoyed by institutions of higher learning. A. According to Reyes versus Court of Appeals, academic freedom is the freedom of a faculty member to pursue his studies in his particular specialty and thereafter to make known or publish the result of his endeavors without fear that retribution would be visited on him in the event that his conclusions are found distasteful or objectionable by the powers that be, whether in the political, economic, or academic establishment. In Garcia versus Faculty Admission Committee, it was held that the academic freedom of an institution of higher learning includes the freedom to determine who may teach, what may be taught, how it shall be taught, and who may be admitted to study. Because of academic freedom, an institution of higher learning can refuse to re-enroll a student who is academically deficient or who has violated the rules of discipline. Academic freedom grants institutions a higher learning the discretion to formulate rules for the granting of honors. Likewise, because of academic freedom, an institution of higher learning can close a school. Q. Undaunted by his three failures in the National Medical Admission Test, NMAT, Cruz applied to take it again, but he was refused because of an order of the Department of Education, Culture and Sports, disallowing flunkers from taking the test a fourth time. Cruz filed suit assailing this rule raising the constitutional grounds of accessible quality education, academic freedom, and equal protection. The government opposed this, upholding the constitutionality of the rule on the ground of exercise of police power. Decide the case discussing the grounds raised. Answer. As held in Department of Education, Culture and Sports versus San Diego, the rule is a valid exercise of police power to ensure that those admitted to the medical profession are qualified. The arguments of Cruz are not meritorious. The right to quality education and academic freedom are not absolute. Under Section 5, Number 3, Article 14 of the Constitution, the right to choose a profession is subject to fair, reasonable, and equitable admission and academic requirements. The rule does not violate equal protection. There is a substantial distinction between medical students and other students. Unlike other professions, the medical profession directly affects the life of the people. Q. Ting, a student of Bangkerohan University, was given a failing grade by Professor Mahigpit. Ting confronted Professor Mahigpit at the corridor after class, and a heated argument ensued. Cooler heads prevented the verbal war, ending in physical confrontation. Mahigpit left the campus and went shopping in a department store. Ting saw Mahigpit and, without any warning, mauled the latter. Mahigpit filed an administrative complaint against Ting before the Dean of Students for breach of university rules and regulations. The Dean set the complaint for hearing. However, Ting filed a petition before the RTC to prohibit the Dean and the school from investigating him, contending that the mauling incident happened outside the school premises and therefore outside the school's jurisdiction. The school and the Dean answered that the school can investigate Ting since his conduct outside school hours and even outside of school premises affect the welfare of the school. And furthermore, the case involves a student and a faculty member. If you were the judge, how would you decide the case? Answer. If I were the judge, I would dismiss the petition. In Angeles versus Season, it was held that the school can subject to disciplinary action a student who assaulted a professor outside the school premises because the misconduct of the student involves his status as a student or affects the good name or reputation of the school. The misconduct of Ting directly affects his suitability as a student. Q. What is the rule on the number of aliens who may enroll in educational institutions in the Philippines? Give the exception to the rule. May such institutions accept donations from foreign students under the pretext that such donations are to be used to buy equipment and improve school facilities? Explain. Answer. Under Section 4, Number 2, Article 14 of the Constitution, no group of aliens shall comprise more than one-third of the enrollment in any school. The exception refers to schools established for foreign diplomatic personnel and their dependents, and unless otherwise provided by law, for other foreign temporary residents. Educational institutions may accept donations from foreign students. No provisions in the Constitution or any law prohibits it. Q. Children who are members of a religious sect have been expelled from their respective public schools for refusing, on account of their religious belief, to take part in the flag ceremony, which includes playing by a band or singing the national anthem, saluting the Philippine flag, and reciting the patriotic pledge. The students and their parents assailed the expulsion on the ground that the school authorities have acted in violation of their rights to free public education, freedom of speech, and religious freedom and worship. Decide the case. Answer. The students cannot be expelled from school, as held in Ebralinag versus the Division Superintendent of Schools of Cebu. To compel students to take part in the flag ceremony when it is against their religious belief will violate their religious freedom. Their expulsion also violates the duty of the state under Article 14, Section 1 of the Constitution, to protect and promote the right of all citizens to quality education and make such education accessible to all. Q. What is the constitutional provision concerning the teaching of religion in the elementary and high schools in the Philippines? Explain. Under Section 3, Number 3, Article 14 of the Constitution, at the option expressed in writing by the parents or guardians, religion can be allowed to be taught to their children or wards in public elementary and high schools within the regular class hours by instructors designated or approved by the religious authorities to which the children or wards belong without additional cost to the government. Q. Give two duties of the state mandated by the Constitution regarding education. Answer. Article 14 of the Constitution imposes the following duties regarding education upon the state. A. The state shall protect and promote the right of all citizens to quality education at all levels and shall take appropriate steps to make such education accessible to all. Section 1. B. The state shall establish, maintain, and support a complete, adequate, and integrated system of education relevant to the needs of the people and society. C. The state shall establish and maintain a system of free public education in the elementary and high school level. Section 2, Number 2. D. The state shall establish and maintain a system of scholarship grants, student loan programs, subsidies, and other incentives which shall be available to deserving students in both public and private schools, especially to the underprivileged. Section 2, Number 3. E. The state shall encourage non-formal, informal, and indigenous learning systems as well as self-learning, independent, and out-of-school study program, particularly those that respond to community needs. Section 2, Number 4. F. The state shall provide adult citizens, the disabled, and out-of-school youth with training in civics, vocational efficiency, and other skills. Section 2, Number 5. G. The state shall take into account regional and sectorial needs and conditions and shall encourage local planning in the development of educational policies and programs. Section 5, Number 1. The state shall enhance the rights of teachers to professional advancement. I. Non-teaching academic and non-academic personnel shall enjoy the protection of the state. Section 5, Number 4. J. The state shall assign the highest budgetary priority to education and ensure that teaching will attract and retain its rightful share of the best available talents through adequate remuneration and other means of job satisfaction and fulfillment. Section 5, Number 5. Q. Bobby, an incoming third-year college student, was denied admission by his university, a premier educational institution in Manila, after he failed in 3 major subjects in his sophomore year. The denial of admission was based on the university's rules and admission policies. Unable to cope with the depression that his non-admission triggered, Bobby committed suicide. His family sued the school for damages, citing the school's grossly unreasonable rules that resulted in the denial of admission. They argued that these rules violated Bobby's human rights and the priority consideration that the Constitution gives to the education of the youth. You are counsel for the university. Explain your arguments in support of the university's case. 2013 bar. A. I shall argue that under Article 14, Section 5, Number 2 of the 1987 Constitution, the educational institution enjoys academic freedom. Academic freedom includes its right to prescribe academic standards, policies, and qualifications for the admission of a student. University of San Agustin versus Court of Appeals. Q. Select any 5 of the following and explain it using example. A. Reprisal. B. Retortion. C. Declaratory tier of recognition principle. D. Recognition of belligerency. E. Continental shelf. F. Exequatur. G. Principle of double criminality. Also asked in 2007 bar. H. Protective personality. I. Innocent passage. J. Jus cogens in international law. Answer. Reprisal is a coercive measure short of war, directed by a state against another in retaliation for acts of the latter and as means of obtaining reparation or satisfaction for such acts. Reprisal involves retaliatory acts which by themselves would be illegal. For example, For violation of a treaty by a state, the aggrieved state seizes on the high seas the ships of the offending state. Letter B. Retortion is a legal but deliberately unfriendly act directed by a state against another in retaliation of an unfriendly though legal act to compel that state to alter its unfriendly conduct. An example of retortion is banning exports to the offending state. C. The declaratory theory of recognition is a theory according to which recognition of a state is merely an acknowledgement of the fact of its existence. In other words, the recognized state already exists and can exist even without such recognition. For example, when other countries recognized Bangladesh, Bangladesh already existed as a state even without such recognition. D. Recognition of belligerency is the formal acknowledgement by a third party of the existence of a state of war between the central government and a portion of that state. Belligerency exists when a sizable portion of the territory of a state is under the effective control of an insurgent community which is seeking to establish a separate government, and the insurgents are in de facto control of a portion of the territory and population, have a political organization, are able to maintain such control, and conduct themselves according to the laws of war. For example, Great Britain recognized a state of belligerency in the United States during the Civil War. E. Continental shelf of a coastal state comprises the seabed and subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory to the outer edge of the continental margin, or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental shelf does not extend up to that distance. Wow. F. Exequatur is an authorization from the receiving state admitting the head of a consular post to the exercise of his functions. For example, if the Philippines appoint a consul general for New York, he cannot start performing his functions unless the President of the United States issues an exequatur to him. Okay. G. The principle of double criminality is the rule in extradition which states that for a request to be honored, the crime for which extradition is requested must be a crime in both the requesting state and the state to which the fugitive has fled. For example, since murder is a crime both in the Philippines and in Canada, under the Treaty on Extradition between the Philippines and Canada, the Philippines can request Canada to extradite a Filipino who has fled to Canada. Double criminality. Protective personality. Letter H. Protective personality principle is the principle by which the state exercises jurisdiction over the acts of an alien, even if committed outside its territory, if such acts are adverse to the interests of the national state. I. Innocent passage means the right of continuous and expeditious navigation of a foreign ship through the territorial sea of a state for the purpose of traversing that sea without entering the internal waters or calling at the roadstead or port facility outside internal waters, or proceeding to or from internal waters, or a call at such roadstead or port facility. The passage is innocent so long as it is not prejudicial to the peace, good order, or security of the coastal state. J. Jus cogens is a preemptory norm of general international law, accepted and recognized by the international community as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. An example is the prohibition against the use of force. Q. How is state sovereignty defined in international law? Sovereignty signifies the right to exercise the functions of a state in regard to a portion of the globe to the exclusion of any other state. It is the principle of exclusive competence of a state in regard to its own territory. Alternative answer. State sovereignty is the ability of a state to act without external controls on the conduct of its affairs. Q. Is state sovereignty absolute? Answer. State sovereignty is not absolute. It is subject to limitations imposed by membership in the family of nations and limitations imposed by treaty stipulations. Tanyada versus Angara. Q. May a treaty violate international law? If your answer is in the affirmative, explain when such may happen. If your answer is in the negative, explain why. Answer. Yes, a treaty may violate international law, understood as general international law, if it conflicts with a preemptory norm or jus cogens of international law. Jus cogens norm is defined as a norm of general international law accepted and recognized by the international community of states as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Article 53 of the Vienna Convention on the Law of Treaties, provided that a treaty is void if at the time of its conclusion it conflicts with jus cogens norm. Moreover, under Article 54 of this convention, if a new preemptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. Q. In February 1990, the Ministry of the Army Republic of Indonesia invited bids for the supply of 500,000 pairs of combat boots for the use of Indonesian Army. The Marikina Shoe Corporation, a Philippine corporation which has no branch office and no assets in Indonesia, submitted a bid to supply 500,000 pairs of combat boots at US $30 per pair, delivered in Jakarta on or before 30th October 1990. The contract was awarded by the Ministry of the Army to Marikina Shoe Corporation and was signed by the parties in Jakarta. Marikina Shoe Corporation was able to deliver only 200,000 pairs of combat boots in Jakarta by 30 October 1990, and it received payment for 100,000 pairs of a total of $3 million. The Ministry of the Army promised to pay for the other 1,000 pairs already delivered as soon as the remaining 300,000 pairs of combat boots are delivered, at which time the said 300,000 spare will also be paid for. Marikina Shoe Corporation failed to deliver any more combat boots. On June 1, 1991, the Republic of Indonesia filed an action before the Regional Trial Court of Pasig to compel Marikina Shoe Corporation to perform the balance of its obligation under the contract and for damages. In its answer, Marikina Shoe Corporation sets up a counterclaim for $3 million, representing the payment of the 100,000 pairs of combat boots already delivered but unpaid. Indonesia moved to dismiss the counterclaim, asserting that it is entitled to sovereign immunity from suit. The trial court denied the motion to dismiss and issued 2 writs of garnishment upon Indonesian government funds deposited in the Philippine National Bank and Far East Bank. Indonesia went to the Court of Appeals on a petition for certiorari under Rule 65 of the Rules of Court. How would the Court of Appeals decide the case? 1991 bar. Answer. The Court of Appeals should dismiss the petition insofar as it seeks to annul the order denying the motion of the government of Indonesia to dismiss the counterclaim. The counterclaim in this case is a compulsory counterclaim since it arises from the same contract involved in the complaint. As such, it must be set up, otherwise it will be barred. Above all, as held in Froilan versus Pan-Oriental Shipping, by filing a complaint, the state of Indonesia waived its immunity from suit. It is not right that it can sue in the courts, but it cannot be sued. The defendant therefore acquires the right to set up a compulsory counterclaim against it. However, the Court of Appeals should grant the petition of the Indonesian government insofar as it sought to annul the garnishment of the funds of Indonesia, which were deposited in the Philippine National Bank and Far East Bank. Consent to the exercise of jurisdiction of a foreign court does not include waiver of the separate immunity from execution. Brown-Lai, Principle of Public International Law. It was held the consent to be sued does not give consent to the attachment of the property of a sovereign government. The state of Nova, controlled by an authoritarian government, had unfriendly relations with its neighboring state, Ameria. Berisha, another neighboring state, had been shipping arms and ammunition to Nova for use in attacking Ameria. To forestall an attack, Ameria placed floating mines on the territorial waters surrounding Nova. Ameria supported a group of rebels organized to overthrow the government of Nova and to replace it with a friendly government. Nova decided to file a case against Ameria in the International Court of Justice. On what grounds may Ameria move to dismiss the case with the International Court of Justice? A. On what grounds may Ameria move to dismiss the case with the International Court of Justice? Decide the case. Answer. By virtue of the principle of sovereign immunity, no sovereign state can be made a party to a proceeding before the International Court of Justice unless it has given its consent. If Ameria has not accepted the jurisdiction of the International Court of Justice, Ameria can invoke the defense of lack of jurisdiction. Even if Ameria has accepted the jurisdiction of the court, but the acceptance is limited and the limitation applies to the case, it may invoke such limitation, its consent, as a bar to the assumption of jurisdiction. If jurisdiction has been accepted, Ameria can invoke the principle of anticipatory self-defense, recognized under customary international law, because Nova is planning to launch an attack against Ameria by using the arms it bought from Brescia. B. If jurisdiction over Ameria is established, the case should be decided in favor of Nova because Ameria violated the principle against the use of force and the principle of non-intervention. The defense of anticipatory self-defense cannot be sustained because there is no showing that Nova had mobilized to such an extent that if Ameria were to wait for Nova to strike first, it would not be able to retaliate. However, if jurisdiction over Ameria is not established, the case should be decided in favor of Ameria because of the principle of sovereign immunity. Q. What do you understand by the doctrine of incorporation in constitutional law? Answer. The doctrine of incorporation means that the rules of international law form part of the law of the land, and no legislative action is required to make them applicable to a country. The Philippines follows this doctrine because Section 2, Article 2 of the Constitution states the Philippines adopt the generally accepted principles of international law as part of the law of the land. Q. What is the doctrine of sovereign immunity in international law? By the doctrine of sovereign immunity, a state, its agents and property are immune from the judicial process of another state, except with its consent. Thus, immunity may be waived, and a state may permit itself to be sued in the courts of another state. Sovereign immunity has developed into two schools of thought, namely absolute immunity and restrictive immunity. By absolute immunity, all acts of a state are covered or protected by immunity. On the other hand, restrictive immunity makes a distinction between governmental or sovereign acts, acts acta jure imperi, and non-governmental propriety, or commercial acts, acta jure gestiones. Only the first category of acts is covered by sovereign immunity. The Philippines adheres to the restrictive immunity school of thought. Alternative answer. In United States versus Ruiz, the Supreme Court explained the doctrine of sovereign immunity in international law. The traditional rule of state immunity exempts a state from being sued in the courts of another state without its consent or waiver. This rule is a necessary consequence of the principle of independence and equality of states. However, the rules of international law are not petrified. They are constantly developing and evolving. I read because the activities of states have multiplied. It has been necessary to distinguish them between sovereign and government acts, jure imperi, and private, commercial and proprietary acts, jure gestionis. The result is that state immunity now extends only to acts jure imperi. Q. An organization of law students has sponsored an inter-school debate among 3 teams with the following assignments and propositions for each team to defend. Team A, international law prevails over municipal law. Team B, municipal law prevails over international law. Team C, a country's constitution prevails over international law, but international law prevails over municipal statutes. If you were given a chance to choose the correct proposition, which would you take and why? Answer: I shall take the proposition for Team C. International law and municipal laws are supreme in their own respective fields. Neither has hegemony over the other. Under Article 2, Section 2 of the 1987 Constitution, the generally accepted principles of international law form part of the law of the land, since they merely have the force of law. If it is Philippine courts that will decide the case, they will uphold the Constitution over international law. If it's in an international tribunal that will decide the case, it will uphold international law over municipal law, as held by the Permanent International Court of Justice in the case of the Polish nationals in Danzig. A state cannot invoke its own constitution to evade obligations incumbent upon it under international law. Alternative answer: I would take the proposition assigned to Team C as being nearer to the legal reality in the Philippines, namely, a country's constitution prevails over international law, but international law prevails over municipal statutes. This is, however, subject to the place of international law in the Philippine constitutional setting, in which treaties or customary norms in international law stand in parity with statutes, and in case of irreconcilable conflict, this may be resolved by lex posteriori derogat lex priori, as the Supreme Court obiter dictum in Abbas versus Comelec. It holds, hence, a statute enacted later than the conclusion or effectivity of a treaty may prevail. In the Philippine legal system, there are no norms higher than constitutional norms. The fact that the Constitution makes generally accepted principles of international law or conventional international law as part of Philippine laws does not make them superior to statutory law, as clarified in Secretariat of Justice versus Lanchon and Philip Morris. Q. What is the principle of author limitation? Answer: under the principle of auto-limitation, any state may be by its consent, express or implied, submit a restriction of its sovereign rights. There may thus be a curtailment of what otherwise is a plenary power. Reagan versus CIR. Q. What is the relationship between reciprocity and the principle of auto-limitation? Answer: by reciprocity, states grant to one another rights or concessions in exchange for identical or comparable duties, thus acquiring a right as an extension of its sovereignty, and at the same time accepting an obligation as a limitation to its sovereign will, hence a complementation of reciprocity and auto-limitation. Q. The dictatorial regime of President A of the Republic of Gordon was toppled by a combined force led by General Abe, former Royal Guards, and the secessionist Gordon People's Army. The new government constituted a Truth and Reconciliation Commission to look into the serious crimes committed under President A's regime. After the hearings, the Commission recommended that an amnesty law be passed to cover even those involved in mass killings of members of indigenous groups who opposed President A. International human rights groups argued that the proposed amnesty law is contrary to international law. Decide with reason. 2010 bar. Answer: the proposed amnesty law is contrary to international law. The mass killings of members of indigenous groups constitute genocide under Article 2, letter A, Convention for the Prevention and Punishment of the Crime of Genocide. The proposed amnesty law is against international law because it is incompatible with or in violation of the international obligation under Article 4 of this convention that persons committing genocide shall be punished, whether they are constitutional responsible rulers, public officials, or private individuals. The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. Q. What is the concept of association under international law? An association is formed when two states of unequal power voluntarily establish durable links. The associate delegates certain responsibilities to the other, the principal, while maintaining its status as a state. It is an association between sovereigns. The associated state arrangement has usually been used as a transitional device of former colonies on their way to full independence. Province of North Cotabato versus GRP Peace Panel, on ancestral domain. Association under international law is a formal arrangement between a non-self-governing territory and an independent state whereby such territory becomes an associated state with internal self-government, but the independent state is responsible for foreign relations and defense. For an association to be lawful, it must comply with the general conditions prescribed in UN General Assembly Resolution 1541, Article 15 of 14 December 160. 1. The population must consent to the association, and 2. The association must promote the development and well-being of the dependent state, the non-self-governing territory. Association is subject to UN approval. Q. State your general understanding of the primary sources and subsidiary sources of international law, giving an illustration of each. Answer. Under Article 38 of the Statute of the International Court of Justice, the primary sources of international law are the following. 1. International Convention, example, Vienna Convention, or the law of treaties. 2. International customs, example, cabotage, the prohibition against slavery and the prohibition against torture. Number 3. General principles of law recognized by civilized nations, example, prescription, res judicata, and due process. The subsidiary source of international law are judicial decisions subject to the provisions of Article 59, example, the decisions in the Anglo-Norwegian fisheries case and Nicaragua versus United States, and teachings of the most highly qualified publicists of various nations, example, Human Rights in International Law by Lauterpacht and International Law by Oppenheim, Lauterpacht. I don't know how to pronounce that last name. Alternative answer. Reflecting general international law. Article 338, number 1 of the Statute of the International Court of Justice is understood as providing for international convention, international custom, and general principles of law as primary sources of international law, while indicating that judicial decisions and teachings of the most highly qualified publicists as subsidiary means for the determination of the rules of law. The primary sources may be considered as formal sources in that they are the methods by which norms of international law are created and recognized. A conventional or treaty norm comes into being by established treaty-making procedures, and a customary norm is the product of the formation of general practice accepted as law. By way of illustrating international convention as a source of law, we may refer to the principle embodied in Article 6 of Vienna Convention on the law of treaties, which reads, "Every state possesses capacity to conclude treaties." It tells us what the law is and the process of method by which it came into being. International custom may be concretely illustrated by pacta sunt servanda, a customary or general norm which came about through extensive and consistent practice by a great number of states recognizing it as obligatory. The subsidiary means serve as evidence of law. Q. The legal yardstick in determining whether usage has become customary international law is expressed in the maxim opinio juris sive necessitates, or opinion juris for short. What does the maxim mean? A. Opinio juris sive necessitates, or simply opinio juris, means that as an element in the formation of customary norm in international law, it is required that states in their conduct amounting to general practice must act out of a sense of legal duty and not only by the motivation of courtesy, convenience, or tradition. According to the International Court of Justice in the North Sea Continental Shelf cases, Reports 1969, para 77, and quoted by the Philippine Supreme Court in Mijares versus Granada, not only must the acts amount to a settled practice, but they must also be such, or be carried out in such a way as to be evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. Q. Under international law, differentiate hard law from soft law. A. Hard law is used to designate a norm or rule of conduct accepted and recognized by the international community of states as a whole, as a source of law binding on them. Hard law produces obligation, which, when breached, gives rise to international responsibility and consequently to reparation. On the other hand, soft law has no binding force and pertains to a statement or declaration of principles with moral force on the conduct of states, but no normative character and without intent to create enforceable obligations. In the depart in the development of international law, a number of soft law principles or declarations have become the basis of norm creation in treaty making and in general practice of states in customary norm formation. Alternative answer: soft law has no binding force and pertains to a statement or declaration of principles with moral force on the conduct of states, but no normative character and without intent to create enforceable obligations. On the other hand, hard law is a norm of rule of conduct accepted and recognized by the international community of states as a whole, as a source of law that is binding on them. Hard law produces obligations which, when breached, gives rise to international responsibility and consequently to reparation. Alternative answer: soft law is an expression of non-binding norms, principles, and practices that influence state behavior. On the other hand, hard law involves binding rules of international law. Pharmaceutical and Healthcare Association of the Philippines versus Duque. Q. What are the sources of international law? The following are the sources of international law. A. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. B. International custom as evidence of a general practice accepted as law. C. The general principles of law recognized by civilized nations. Q. What is opinion? Opinio juris in international law. Answer: to establish customary international law, two elements must concur: the general state practice and opinio juris sive necessitates or necessitatis. State practice refers to the continuous repetition of the same or similar kind of acts or norms by states. Opinio juris requires that the state practice or norm be carried out in such a way as to be evidence of the belief that it is obligatory by the existence of a rule of law requiring it. Bayan Muna versus Romulo. Q. The Japanese government confirmed that during the Second World War, Filipinas were among those conscripted as comfort women or prostitutes for Japanese troops in various parts of Asia. The Japanese government has accordingly launched a goodwill campaign and has offered the Philippine government substantial assistance for a program that will promote, through government and non-governmental organizations, women's rights, child welfare, and nutrition and family health care. An executive agreement is about to be signed for the purpose. The agreement includes a clause whereby the Philippine government acknowledged that any liability to the comfort women or their descendants are deemed covered by the reparations agreements signed and implemented immediately after the Second World War. Juliano Iglesias, a descendant of a now deceased comfort woman, seeks your advice on the validity of the agreement. Advise him. Answer: the agreement is valid. The comfort women and their descendants cannot assert individual claims against Japan as stated in Davis and Moore versus Reagan. The sovereign authority of a state to settle claims of its nationals against foreign countries has repeatedly been recognized. This may be made without the consent of the nationals or even without consultation with them. Since the continued amity between the state and other countries may require a satisfactory compromise of mutual claims, the necessary power to make such compromises has been recognized. The settlement of such claim may be made by executive agreement. Q. Distinguish between de facto recognition and de jure recognition of states. Answer: the following are the distinctions between de facto recognition and de jure recognition of a government. A. The following are the distinctions between de facto recognition and the de jure recognition of a government. A. De facto recognition is provisional. De jure recognition is relatively permanent. B. De facto recognition does not vest title in the government to its properties abroad. De jure recognition does. C. De facto recognition is limited to certain juridical relations. De jure recognition brings about full diplomatic relations. Alternative answer: the distinction between de facto recognition and de jure recognition of a state is not clear in international law. It is, however, usually assumed as a point of distinction that while de facto recognition is provisional and hence may be withdrawn, de jure recognition is final and cannot be withdrawn. Confronted with the emergence of a new political entity in the international committee, a state may experience some difficulty in responding to the question whether the new political order qualifies to be regarded as a state under international law, in particular from the viewpoint of its effectiveness and independence on a permanent basis. The recognizing state may consider its act in regard to the new political entity as merely a de facto recognition, implying that it may withdraw it if in the end it turns out that the conditions of statehood are not fulfilled should the new authority not remain in power. But even then, a de facto recognition in this context produces legal effects in the same way as de jure recognition. Whether recognition is de facto or de jure, the steps may be taken to withdraw recognition if the conditions of statehood in international law are not fulfilled. Thus, from this standpoint, the distinction is not legally significant. Q. Distinguish the constitutive theory and the declaratory theory concerning recognition of states. A. According to the constitutive theory, recognition is the last indispensable element that converts the state being recognized into an international person. According to the declaratory theory, recognition is merely an acknowledgement of the pre-existing fact that the state being recognized is an international person. Q. Discuss the differences, if any, and the privileges or immunities of diplomatic envoys and consular officers from the civil or criminal jurisdiction of the receiving state. 2. A consul of a South American country stationed in Manila was charged with serious physical injuries. May he claim immunity from jurisdiction of the local court? Explain. 3. Suppose after he was charged, he was appointed as his country's ambassador to the Philippines. Can his newly gained diplomatic status be a ground for dismissal of a criminal case? Answer to number 1. Under Article 32 of the Vienna Convention on Diplomatic Relations, a diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. He shall also enjoy immunity from its civil and administrative jurisdiction, except in the case of a real action relating to private immovable property situated in the territory of the receiving state, unless he holds it on behalf of the sending state for the purposes of the mission. B. An action relating to succession in which the diplomatic agent is invoked as executor, administrator, heir, or legatee as a private person, and not on behalf of the sending state. C. An action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. On the other hand, under Article 41 of the Vienna Convention on Consular Relations, a consular officer does not enjoy immunity from a criminal jurisdiction of the receiving state. Under Article 43 of the Vienna Convention on Consular Relations, consular officers are not amenable to the jurisdiction of the judicial or administrative authorities of the receiving state in respect of acts performed in the exercise of consular functions. However, this does not apply in respect to a civil action either. A. Arising out of a contract concluded by a consular officer in which he did not contract expressly or impliedly as an agent or sending state, or by a third party for damage arising from an accident in the receiving state caused by a vehicle, vessel, or aircraft. Number 2. No, he may not claim immunity from the jurisdiction of the local court. Under Article 41 of the Vienna Convention of Consular Relations, consuls do not enjoy immunity from the criminal jurisdiction of the receiving state. He is not liable to arrest or detention pending trial, unless the offense was committed against his father, mother, child, ascendant, descendant, or spouse. Consuls are not liable to arrest and detention pending trial except in the case of a grave crime and pursuant to a decision by the competent judicial authority. The crime of physical injuries is not a grave crime unless it be committed against any of the above mentioned persons. Number 3. Yes, the case should be dismissed under Article 40 of the Vienna Convention on Diplomatic Relations if a diplomatic agent is in the territory of a third state, which he granted him a passport visa, if such visa was necessary while proceeding to take up his post, the third state shall accord him inviolability and such other immunities as may be required to ensure his transit. Q. A foreign ambassador to the Philippines leased a vacation house in Tagaytay for his personal use. For some reason, he failed to pay rentals for more than 1 year. The lessor filed an action for the recovery of his property in court. A. Can the foreign ambassador invoke his diplomatic immunity to resist the lessor's action? B. The lessor gets hold of evidence that the ambassador is about to return to his home country. Can the lessor ask the court to stop the ambassador's departure from the Philippines? Answer to letter A. No, the foreign ambassador cannot invoke his diplomatic immunity to resist the action, since he is not using the house in Tagaytay City for the purpose of his mission, but merely for vacation. Under Article 3, Number 1, letter A of the Vienna Convention on Diplomatic Relations, a diplomatic agent has no immunity in case of a real action relating to private immovable property situated in the territory of the receiving state unless he holds it on behalf of the sending state for purposes of the mission. Letter B. No, the lessor cannot ask the court to stop the departure of the ambassador from the Philippines. Under Article 29 of the Vienna Convention, a diplomatic agent shall not be liable to any form of arrest or detention. Q. Dr. Velen, an official of the World Health Organization assigned in the Philippines, arrived at the Ninoy Aquino International Airport with his personal effects contained in 12 crates as unaccompanied baggage. As such, his personal effects were allowed free entry from duties and taxes and were directly stored at Arshane Corporation's warehouse at Makati, pending Dr. Velen's relocation to his permanent quarters. At the instance of police authorities, the Regional Trial Court of Manila issued a warrant for the search and seizure of Dr. Velen's personal effects in view of an alleged violation of the Tariff and Custom Code. According to the police, the crates contained contraband items. Upon protests of WHO officials, the Secretary of Foreign Affairs formally advised that RTC as to Dr. Velen's immunity. The Solicitor General likewise joined Dr. Velen's plea of immunity and motion to quash the search warrant. The RTC denied the motion. Is the denial of the motion to quash proper? Answer. The denial of the motion to quash is improper, as held in World Health Organization versus Aquino. As an official of the World Health Organization, Dr. Velen enjoyed diplomatic immunity, and this included exemption from duties and taxes. Since diplomatic immunity involves a political question, where a plea of diplomatic immunity is recognized and affirmed by the executive department, it is the duty of the court to accept the claim of immunity. Q. A group of high-ranking officials and rank-and-file employees stationed in the foreign embassy in Manila were arrested outside embassy grounds and detained at Camp Crame on suspicion that they were actively collaborating with terrorists out to overthrow or destabilize the Philippine government. The foreign ambassador sought their immediate release, claiming that the detained embassy official and employees enjoyed diplomatic immunity. If invited to express your legal opinion on the matter, what advice would you give? Answer. I shall advise that the high-ranking officials and rank-and-file employees be released because of their diplomatic immunity. Article 29 of the Vienna Convention on Diplomatic Relations provides, the person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. Under Article 37 of the Vienna Convention on Diplomatic Relations, members of the administrative and technical staff of the diplomatic mission shall, if they are not nationals of any permanent residence in the receiving state, enjoy the privileges and immunities specified in Article 29.
Under Article 9 of the Vienna Convention on Diplomatic Relations, the remedy is to declare the high-ranking officials and rank-and-file employees personae non grata and ask them to leave. Alternative answer. Under the Vienna Convention on Diplomatic Relations, a diplomatic agent shall not be liable to any form of arrest or detention, Article 29, and he enjoys immunity from criminal jurisdiction. Article 31. This immunity may cover the high-ranking official in question who are assumed to be diplomatic officers or agents. With respect to the rank-and-file employees, they are covered by the immunity referred to above, provided they are not nationals or permanent residents of the Philippines, pursuant to Article 37, Number 2 of the said convention. If the said rank-and-file employees belong to the service staff of the diplomatic mission, such as drivers, they may be covered by the immunity, even if they are not Philippine nationals or residents, as set out in Article 37, Number 3. If at the time of the arrest they were in acts performed in the course of their duties, if a driver was among the said rank and file employees and he was arrested while driving a diplomatic vehicle or engaged in related acts, still he would be covered by immunity. Q. MBC, an alien businessman dealing in carpets and caviar, filed a suit against policeman NYC, an attached of XX Embassy, for damages because of malicious prosecution. MBC alleged that YC concocted false and malicious charges that he was engaged in drug trafficking, whereupon narcotics policemen conducted a bypass operation and without warrant arrested him, searched his house, and seized his money and jewelry, then detained and tortured him in violation of his civil and human rights, as well as causing him, his family, and business serious damages amounting to 2 million pesos. MBC added that the trial court acquitted him of the drug charges. Assailing the court's jurisdiction, YZ now moves to dismiss the complaint on the ground that 1. He is an embassy officer entitled to diplomatic immunity, and that 2. The suit is really a suit against his home state without its consent. He presents diplomatic notes from XX Embassy certifying that he is an accredited embassy officer recognized by the Philippine government. He performs official duties, he says, on a mission to conduct surveillance on the drug exporters and then inform local police officers who make the actual arrest of suspects. Are the two grounds cited by YC to dismiss the suit tenable? Answer. The claim of diplomatic immunity of YC is not tenable because he does not possess an acknowledged diplomatic title and is not performing duties of a diplomatic nature. However, the suit against him is a suit against XX without its consent. XYZ was acting as an agent of XX and was performing his official functions when he conducted surveillance on drug exporters and informed the local police officers who arrested MBC. He was performing such duties with the consent of the Philippine government. Therefore, the suit against YZ is a suit against XX without its consent. Miniature versus Court of Appeals. Q. Italy, through its ambassador, entered into a contract with Abad for the maintenance and repair of specified equipment as its embassy and ambassador's residence, such as air conditioning units, generator sets, electrical facilities, water heaters, and water motor pumps. It was stipulated that the agreement shall be effective for a period of 4 years and automatically renewed unless cancelled. Further, it provided that any suit arising from the contract shall be filed with the proper courts in the city of Manila. Claiming that the maintenance contract was unilaterally, baselessly, and arbitrarily terminated, Abad sued the state of Italy and its ambassador before a court in the city of Manila. Among the defenses they raised were sovereign immunity and diplomatic immunity. A. As counsel of Abad, refute the defenses of sovereign immunity and diplomatic immunity raised by the state of Italy and its ambassador. B. At any rate, what should be the court's ruling on the said defenses? As counsel for Abad, I will argue that sovereign immunity will not lie as It is an established rule that when a state enters into a contract, it waives its immunity and allows itself to be sued. Moreover, moreover, there is a provision in the contract that any suit arising therefrom shall be filed with the proper courts of the City of Manila. On the issue of diplomatic immunity, I will assert that the act of the ambassador unilaterally terminating the agreement is tortious and done with malice and bad faith and not a sovereign or diplomatic function. B. The court should rule against said defenses. The maintenance contract and repair of the embassy and ambassador's residence is a contract in use imperi, because such repair of said buildings is indispensable to the performance of the official functions of the government of Italy. Hence the contract is in pursuit of a sovereign activity, in which case it cannot be deemed to have waived its immunity from suit. On the matter of whether or not the ambassador may be sued, Article 31 of the Vienna Convention on Diplomatic Relations provides that a diplomatic agent enjoys immunity from the criminal, civil, and administrative jurisdiction of the receiving state, except if the act performed is outside his official functions, in accordance with the principle of functional necessity. In this case, the act of entering into the contract by the ambassador was part of his official functions, and thus he is entitled to the diplomatic immunity. Republic of Indonesia versus Binsons.